Well, we might give everyone a start. So hello and welcome to our Q&A webinar today, Employment Law Update on Annualised Wage Arrangements. My name is Lauren Berry. I'm the People and Culture Manager here at Employment Hero, and I'm joined by two very special guest speakers, Brooke Brown, who is the Senior HR Business Partner at Employment Innovations, and Aahana Lakhia, who is the Senior Lawyer at EI Legal. Welcome, Brooke and Aahana. Thank you so much for joining us today.
Thank you, Lauren, for having us.
Thanks, Lauren.
No problem. Very excited to have you join us, and I'm sure we're going to get through some really interesting content. So before we start, and before I pass over to Brooke and Aahana, I'd just like to acknowledge the Aboriginal and Torres Strait Islander peoples as the first Australians and traditional custodians of the land where we live, work and learn. Also, just a couple of housekeeping elements that I want to touch on at the moment. We've allocated time at the end of the webinar to answer questions. So if you have a question, please don't hesitate to type it into the question box at the bottom of your screen. If you look down at the bottom of the webinar screen, there will be a Q&A box, and that's where you need to pop in all of your questions. We'll get through as many as we can after the presentation. And as I said, yes, this session is being recorded, so we'll also make it available as part of our on-demand webinar post the event. But I might hand over to Brooke and Aahana to take us through our employment law update for today.
Thank you, Lauren. I'll start with myself. So thank you everyone for joining. I'm Brooke Brown, as Lauren mentioned. I'm a Senior HR Partner here at Employment Innovations. I work with businesses across many industries of many sizes. Employment Innovations is a professional services company, and we are the sister company of Employment Hero. We work as a dedicated team of HR and payroll professionals that provide outsourced solutions to small and medium-sized enterprises. So we also have services across legal and migration, and we act as an extension of businesses essentially. Within this space, we also utilize many technology platforms, one main being Employment Hero, and we use KeyPay, which is also known as Employment Hero Payroll, as the payroll software. And these are really important platforms that we use to optimize the delivery of our services across these businesses that we work hand in hand in. So they're super important and significant, and will play a part in what we discuss today. I will hand you over to Aahana to introduce herself and EI Legal.
Great, thanks for the introduction, Brooke and Lauren. As Brooke mentioned, I'm a senior lawyer at EI Legal, and EI Legal is a sister company of Employment Innovations and also Employment Hero. So EI Legal is basically a specialist employment law firm. So all of our lawyers are specialists in the field, and we essentially aim to provide accessible legal advice to our clients at affordable prices. And we're really able to do this through our partnership with Employment Innovations and Employment Hero, which basically means that our clients don't have to spend sort of excessive legal fees for matters that can ideally be dealt with by a HR professional such as Brooke. And we'd often closely work with our HR partners at EI to provide strategic advice to our clients. When clients do need legal advice, we provide a range of sort of bespoke advice. If they really need something that's a little bit more complicated, so for example, we do represent clients in unfair dismissals and general protections in the Fair Work Commission and the federal courts. And we also provide tailored advice to our clients regarding tricky terminations, award interpretations. And of course, most recently, we've assisted clients navigate through these recent changes to the Restaurant and Hospitality Awards. And we will obviously go through that in detail with you today. But I did want to make clear that there is a lot of information that is going to be shared. It is quite complicated, although it's meant to be quite informative. Whatever we say today is not meant to be legal advice. So if you do need assistance, please feel free to reach out to either Brooke or myself, and one of the team members would be happy to have a chat with you.
Thanks, Aahana. We may just go through today's agenda. So we will be discussing the main changes that have come into play from September 1st, and I am conscious that these are already in effect. So we'll work through what this means for you and your business. We will discuss the outer limit provisions, which affects penalty rates and overtime hours. There will also discuss the differences between restaurant and hospitality award. Then there are not many, but there are a few slight variations, which we'll point out. We will then run through a worked example, so practical patterns of hours and what would be affected by these new provisions. We will then talk about record keeping and reconciliation obligations, which still stand in light of these provisions being introduced. Written agreements, what will need to be in place in terms of documentation. What if you pay above the minimum salary? So considerations that you may want to reflect on post this webinar. Some frequently asked questions and practical next steps that we recommend your business considers when looking at the changes and what you need to put into place within your business. We will then talk briefly about some resources that we will be providing you, but this will also be shared post-webinar, and then we'll run through some Q&A. So hopefully if you do have some questions, they'll either be answered throughout the content or we'll hope to get to them at the end. Moving on to the changes from September 1st, Aahana, if you wanted to run through that.
Fantastic, thanks, Brooke. Okay, so diving right in, on the 1st of September, there were changes which were implemented to both the Restaurant Industry Award, which you'll hear us refer to as AREA, and the Hospitality Industry General Award, which you refer to as HIGA, just for ease of reference. Now, under the AREA, it was clause 20, and under the HIGA, it was clause 24. And essentially, these provisions have replaced the previous annualised wage arrangements that were in the award. So what you need to be mindful of if you're intending to pay a full-time employee an annualised salary moving forward is to make sure that you comply with these new provisions that came into effect from the 1st of September. So by way of brief summary, I'll just sort of run through what the changes are. The annualised wage arrangement provisions now only refer to full-time employees, not part-time employees. So any annual salaries for part-time employees must actually cover all entitlements in each pay period. So you can only engage with these provisions for full-time employees, which is a very important change to be mindful of. The other sort of thing to be mindful of is if you are paying an annualised salary under these provisions, it now also refers to annual leave loading, allowances, as well as overtime and penalty rates as being included in that annual salary. So we'll talk a little bit about how that salary is calculated, but it does include leave loading and allowances as well as overtime and penalties. But it's never that straightforward. With the overtime and penalties, basically what has now been introduced is what's called an outer limit on the number of overtime or penalty rates that can be worked in a roster cycle. And the maximum roster cycle is 4 weeks. So basically, if an employee works in excess of what these outer limits now are, they must be paid for these at that relevant time. So during that pay period. It can't be paid at the end of the year at the time of annual reconciliation. It actually has to be paid during the relevant pay period if that employee works outside of those outer limits. And I will go through that in a bit more detail shortly. The other important thing to note is the annual reconciliation is still necessary, even if the employee is working within the outer limits. So every year, or if an employee's employment is terminated, that reconciliation obligation still exists. So that still needs to be undertaken. The other important point is that the written agreement between the employer and the employee, it must refer to these outer limits. And therefore, if you have any sort of arrangements in place with your full-time employees at the moment, you're really going to need to enter into a new written agreement to ensure that it highlights all the changes and specifically the outer limits. The annual reconciliation process is essentially the same. There are a couple of changes, but again, we'll go through that shortly. but yeah, so it's just very important to know that that sort of annual reconciliation process doesn't just fall away. The other change is that there's now no longer a requirement for employers to provide employees with time in lieu for working on a public holiday. That used to be a provision under the old annualised salary provisions, but that no longer stands. There are some other sort of differences between the restaurant industry award and the hospitality industry award in relation to working on public holidays when it falls on a rostered day off, which I'll go through shortly. And the only thing I guess I just want to note is employees who are classified under the managerial staff hotels classification under the HIGA, they can still be paid a salary of 25% above the minimum award, which is in satisfaction of all monetary entitlements arising under the award. So that hasn't been affected by the changes that have come through on the 1st of September. All right, so moving on to the next slide, I guess this is sort of the biggest change that has been introduced is the introduction of what's called these outer limits. I'll go through the outer limits in relation to penalty rates and overtime separately in a little bit more detail, but I thought it'd be important to sort of explain the rationale behind the outer limits. So essentially, when the Fair Work Commission was reaching its decision, they noted that it was important to implement what's called outer limits to ensure that the annualised wage arrangements are not exploited, so that employees in a particular roster period are being required to work sort of extreme hours, or what the Fair Work Commission referred to as unsociable hours. Essentially, the outer limits were introduced to combat this by requiring employees to be paid in addition additional amounts at the time they work outside of these outer limits. But it is important to note that it doesn't actually prevent an employer from rostering employees outside of the outer limits. You can still do that, and you can do that on a regular basis. It's just that if employees do work outside of the outer limits, this annualised wage arrangement won't cover them, and the employer will sort of have to pay the employee for that time during the relevant pay period. But in summary, the reason sort of the Fair Work Commission put it in place is just sort of avoid the whole set and forget mentality of having employees on an annual salary and sort of forgetting, not sort of having regard to what hours they work. On the other hand, the Fair Work Commission did, however, also take into consideration that in an industry like the restaurant industry and the hospitality industry, employees do work additional hours, especially during peak periods, on evenings, on weekends, on public holidays. And so when setting those outer limits, they did sort of take that into consideration and set them at a slightly sort of higher rate. Okay, so moving on to then what the outer limits are. So as I mentioned previously, there's now an outer limit, which is an average of 18 ordinary hours, which would ordinarily attract a penalty rate. This is under clause 24.2 of the HIGA and 20.2 of the RIA. We will obviously share the slides later, which will have reference to relevant clauses, but for the purposes of, I guess, our webinar, I'm not going to go through each clause reference to confuse everyone. So essentially what the outer limits now say is that an employee can only be rostered in a particular week or averaged over a roster cycle, which can be the maximum of 4 weeks, to work 18 penalty hours. Now, the penalty hours usually under both restaurant and hospitality awards are Monday to Friday between midnight to 6 a.m. Under RIA, or midnight to 7 a.m. under HIGA. Any hours worked on a Saturday, which is usually penalties, any hours worked on a Sunday, and any hours worked on a public holiday. So all those, any ordinary hours worked on those during those times will attract a penalty rate, and therefore those hours will count towards those 18 hours of the outer limit. If employees then work in excess of those 18 penalty hours, that must be paid for by the employer. So the employer must pay that during the relevant pay period. There is, however, an exception. Once again, they don't make it that straightforward. Any hours which are worked between Monday to Friday, between 7 p.m. to midnight, under hospitality, or between 10 p.m. to midnight under the restaurant, that's actually excluded from the outer limit. So essentially, say for example, an employee at a pub covered by the Hospitality Industry Award, they work any hours between 7 p.m. to midnight. That ordinarily attracts a penalty rate, but essentially what the new provisions state is that there's an exclusion in that any hours between 7 p.m. to midnight won't have to be counted towards those 18 hours. The reason being is that the Fair Work Commission did take into consideration that employees, especially like, you know, in the industry, they would reasonably be expected to work evening, you know, late night. So I thought it was important to sort of take that into consideration. But it is important to note that employees still don't lose the financial benefit of the penalty rates that will usually apply between 7 p.m. to midnight or 10 p.m. to midnight under the restaurant. So what I mean by that is the obligation when you undertake an annual reconciliation. So when you undertake that reconciliation at the end of the year, you still need to account for any hours worked during that time. So between 7 p.m. to midnight, for example, under the Hospitality Award. And that does need to be taken into consideration at the relevant time. So that's essentially in relation to penalty hours. So just by way of summary, if an employee works in excess of an average of 18 ordinary hours, which would normally attract a penalty rate, subject to that small exclusion, then they must be paid for these hours at the relevant time. So say, for example, an employee worked 19 penalty hours in 1 week, that 19th hour would need to be paid during that pay period on top of the annual salary. So that's essentially the outer limit in relation to penalty rates. Moving on then to the outer limits in relation to overtime. The overtime outer limit that has now been set is 12 hours per week. Now, overtime for full-time employees usually includes weekly overtime, so working in excess of 38 ordinary hours per week. Again, this can be averaged over 4 weeks. There's also daily overtime. So if an employee works over 11.5 hours in a day, excluding any meal breaks, that also triggers overtime. And there's other sort of provisions that trigger overtime, which are, so for example, not being provided with a 48-hour break after working more than 10 ordinary hours on more than 3 consecutive days, working in excess of 8 days of more than 10 ordinary hours in a 4-week cycle, not being provided a minimum break of 10 hours between when the employee finishes their ordinary hours on one day and then starts their ordinary hours on the other day, and then working beyond a spread of 12 hours for an employee who works split shifts. So these are basically all the circumstances in which overtime would be triggered. And the provisions basically now say that an employee can work up to 12 hours, which would attract overtime, and anything on top of that, similar to the outer limit for penalty rates, must be paid for at the relevant time, so during the pay period. Okay, so that's basically what the outer limit rules are. Just briefly, I appreciate there's slight changes between the restaurant industry and hospitality industry awards, so thought we'd include a brief summary of what the changes are. Essentially, as I explained before, the outer limits in relation to penalty rates, there is an exclusion of hours which are worked between 10 p.m. to midnight under the Restaurant Industry Award, or 7 p.m. to midnight under the Hospitality Industry Award. So any hours, ordinary hours worked during that time, which would ordinarily attract a penalty rate, that's not counted towards the outer limit, but still needs to be taken into consideration for the reconciliation. The other difference is in relation to when a public holiday falls on a RDO. So under the Restaurant Industry Award, payment for the public holiday is still payable outside of that salary. However, under the Hospitality Industry Award, that's specifically excluded under the annualised wage arrangement. So the provision now states that any payment for public holiday falling on an RDO is actually included in the annual salary and doesn't have to be made on top, unlike in the Restaurant Industry Award. And lastly, under the Hospitality Industry Award, as I mentioned before, there's no changes to Clause 25, which deals with salaries for managerial staff. So they can just be paid a 25% buffer and it covers all the entitlements. So that hasn't been changed on the 1st of September. All right, over to you now, Brooke.
Thanks, Aahana. That was a really in-depth overview of the changes, and I might just wrap up with a summary of what you said with some important points to take away. Again, this only applies to full-time employees. Part-time employees need to ensure that we satisfy their entitlements pay period to pay period, because this averaging provision does not apply to them and the outer limits does not apply to pro rata part-time employees. Like Aahana said, does not apply to the managerial classifications and provisions under the Hospitality Industry Award. So they will still stand under Clause 25 of that award. And the really important thing to mention is that just because an employee does not meet that threshold of the outer limit provision, so they don't work those 18 hours, penalty hours, or they don't work those 12 overtime hours in that pay cycle or roster cycle, does not mean we can kind of set and forget. We need to ensure that their salary meets the 125% minimum wage as the first point, as starting point, and then ensure that the hours that they've worked throughout that course of the year still meet the reconciliation obligations and provisions, meaning if there is a difference between what they would have earned as a full-time hourly employee versus what they've earned as a salaried employee, we need to ensure that we make good the shortfall. So we pay them the difference at the end of the 12 months or when their employment ceases. Moving on to some practical examples, which we hope helps kind of bring all these provisions and legislative provisions together. So working through example 1, so what you can see on your screen at the moment is an example of a trade qualified chef, a level 4 under either HIGA or RIA. And we've put together a 40-hour week roster cycle, and this is based on a weekly roster cycle, so not averaging over the 4-week or fortnightly period, just looking at the weekly roster cycle. We've put the minimum salary, remember, pre-October 1st, which is going to change and complicate things next week onwards, but we'll discuss that and go over that in a second, is $58,460. Am I reading that right? 67.50 cents. That is the minimum level 4 rate with the 25% buffer. We've based these patterns of hours on a Wednesday to Sunday working week, so a 5-day working week with 2 hours of overtime being 2 hours over 38 hours. And then we've looked at the patterns of hours. As you can see, there's some shift entitlements in the second last column and the outer limit allocation. So what I wanted to make clear today is that the allocation of outer limits can only be attributed to one set of outer limit allocation, essentially. So what that means is you can see on the Friday roster, this person has gone over 1.5 hours of penalty rates. into the Saturday shift. And then we can see Saturday rates apply on the Saturday rate, Sunday rates apply on the first 6.5 hours of the Sunday. And the last 2 hours is attributed to the overtime outer limit provisions. That being is the overtime provisions, which is 200%, supersedes the penalty hours. So the last 2 hours, which is from the 38th hour to the 40th hour, goes towards the outer limit allocation of the overtime provisions. So as we can see here, there was some hours in which were allocated to these new outer limit provisions, but you can see within the columns below that we haven't gone over those thresholds. So we've looked at, based on this roster, we've done 15.5 hours of penalty hours, and we've done 2 hours of overtime, meaning that those total hours still come below those maximum thresholds. So within this worked example, there would be no payments that we need to make good in this pay cycle, but again, it still contributes to the assessment we would need to do at the end of the 12 months, okay? Moving forward to a second example, and I note in the first example that is probably more in line with a very low season of what we work with within these industries that we know. Worked example 2, we've tried to do an example that's based on more of a peak season. So we're using the same details, which is a trade qualified chef, level 4, $58,000 salary with the 25% buffer. But then we've changed the patterns of hours. So you can see in this example 2, this is based on a 45-hour week, still a 5-day roster, Wednesday to Sunday, but we have 5 more hours per week that we're working with, and we can see the impacts of this. So we've also thrown in, as a spanner in the works, which we've had last week, Wednesday being a public holiday. So remember, Wednesday contributes to penalty hours. So it is included within the outer limit penalty hour allocation. So we can see on Wednesday that those 9.5 hour shift, which is a 200% penalty public holiday rate, is attributed to the penalty hours outer limit allocation. Then we can see that between Wednesday and Thursday, we finished at midnight, and we started at, Thursday and Friday. My screen's very small. Between Thursday and Friday, we have a less than a 10-hour break, and it wasn't a changeover in roster, meaning that the whole shift in the Friday shift is actually less than a 10-hour gap between shifts, which attributes to overtime outer limit allocation. So we can see just through a couple of small changes, there are some big impacts with how this interacts with new outer limit provisions. We can see on the Saturday that allocation is attributed to the outer limit penalty hours because it doesn't attract overtime, but it is within penalty rate provisions. And then the last bit is the Sunday rate, which we can see that whole Sunday shift, the 7-hour Sunday shift, attributes to the outer limit allocation of overtime because we've done 7 hours over 38, which means the hours between 38 and 45, which is 7 hours, is allocated to the overtime hours. So you're never going to double dip, but one doesn't exclude or offset the other. It will always be attributed to one set of allocation. So we can see in this example that the penalty hours have gone over half an hour because the total calculation of penalty hours, we've done 18.5 hours within this weekly roster cycle. So that means we need to pay 30 minutes of penalty hours, which would fall on that Saturday rate. And then the next bit is the overtime hours. And because we didn't have that more than 10-hour break between shifts, we can see that we've actually calculated a total of 15 hours within this week that are allocated to the overtime hours, meaning that we've gone 3 hours over the threshold of the outer limit provisions that have come into play, meaning we need to make 30-minute payment of penalty rates and a 3-hour payment of overtime rates, and the overtime rates would be on that 200%. hope that makes sense, and that helps with the kind of practical aspects of what this would look like in your payroll and your roster. I might just bring it all together and give you a summary of what you need to consider if you were employing someone on an annual salary across kind of a 12-month period, and how that interacts with the reconciliation payment in a practical sense. So using the same example, we have a chef level 4 on the same salary. And we're looking at that first example that I used. Like I said, we're having that as an extension of likely to be a low to mid season because it was only 40 hours a week, which is quite low within industry standard. If we use that example over a 9-month period, that calculates to around $43,000 worth of what they would have been paid if they were a full-time hourly employee. Okay. Then we looked at the high season, which was example 2, and I've put that over about a 3-month period. So say your summer season. If they worked those 3 months as a full-time hourly employee, they would have earned $22,500. So if we bring that all together, we add the 9 months with the 3-month period for a total of a 12-month service period, we can see that the salary reconciliation comes to $66,350 essentially, which is above the minimum salary that we paid at 125%. What I want to make clear is that any outer limit payments that you've made throughout that 12-month period, like we saw in example 2, we had to make some payments within that pay cycle, that will be deducted from your reconciliation payment because you don't need to pay it twice. If you've paid the outer limits, that will reduce the overall reconciliation payment. So we can see that even though we had a 3-month period that we went over the outer limit payments and we had to make good those payments within that pay cycle, we can see that that 125% salary, which is that 58,000, still was not enough to cover the weekends and Saturdays that we've worked and Sundays and things like that. So making clear that that $3,000 that we've paid over that outer limit threshold will then be reduced from the 12-month reconciliation payment, which would leave you with that $4,000 outstanding payment to make good of the shortfall that that employee didn't make on a salary. So it still is very relevant, this reconciliation payment that we're used to doing already, but hopefully that helps give you a summary of how the new provisions work in interaction of the existing provisions. Moving on, Aahana, I hope that summarized everything in a practical sense as best as possible. It's very complex, but I might just pass over to you to talk about the other provisions that have come into play in terms of record keeping and the reconciliation payments.
Great, thanks, Brooke. Okay, so there are other sort of obligations under these new provisions. The award now specifically requires employers to keep a record of the starting and finishing times of work and any unpaid breaks taken by employees. And in addition to that, these records must be signed by the employee or acknowledged as correct in writing. And this can be via electronic means, but essentially the employee during each pay period or roster cycle needs to sign record or acknowledge in writing that it is accurate. In practical terms, we appreciate that this can be quite difficult, but this obligation may be met by implementing a time and attendance software, which enables employees to clock in at the start of a shift, clock out at the end, and also log in any unpaid meal breaks, and then also sort of acknowledge at the end of each pay period that the hours are correct. And that might be, for example, sort of ticking a box that says I acknowledge and agree that these hours are correct. But obviously this is something that operationally our clients will have to look at when engaging with these provisions, but it is very important to keep in mind that this record keeping obligation does now exist, and unfortunately it is quite onerous. In addition to monitoring hours then which are worked outside of the outer limits and having to top up employees during each pay period, As I mentioned previously, there is now also an obligation, well, there always was, but it still remains an obligation to undertake an annual reconciliation of the hours worked by employees when you're engaging with these provisions. So keeping in mind, of course, this reconciliation also has to be performed if the employee's employment is terminated during any period during the year. So essentially, whilst undertaking that reconciliation, if it is identified that there is an underpayment, any top-up payments made to the employee during the year for working in excess of those outer limits, it will contribute towards the total earnings of the employee, and it does reduce the value of any payment made to the employees. It's not like there's going to be double dipping, but again, it is very important to undertake that annual reconciliation for each hour worked by the employee. And lastly, once that reconciliation is undertaken, and if any underpayment is identified, an employer must pay that shortfall to the employee within 14 days. So those are, I guess, the record keeping and reconciliation obligations. Moving on then on the obligation to actually have a written agreement with the employee where you intend on engaging with these provisions. So essentially, if you're looking at providing a full-time employee an annualised wage in accordance with these provisions under the award, there must be a written agreement in writing with the employee. That written agreement must specify a couple of things. It must specify the annualised wage that's going to be paid to the employee. It then must also specify clearly what provisions of the award will be satisfied by payment of the annualised wage. For example, annual leave loading and allowances. And on top of that, it must clearly stipulate the outer limit of the number of ordinary hours, which would attract the payment of a penalty rate, which is 18 hours, and the outer limit number of overtime hours, which the employee may be required to work in a roster cycle, which is 12 hours. Now, just keeping in mind, if you have any existing agreements in place with employees, that's not going to include any provision in relation to these outer limits. So it's very important that if you do wish to pay employees an annualised wage, and by employees I mean full-time employees under these provisions, you need to enter into brand new written agreements with them to satisfy these obligations under the award. And lastly, just keeping in mind that the annualised wage agreement, where it has been reached in writing, it can be terminated by the employer or the employee by giving 12 months written notice of the termination, or it can be terminated at any time by written agreement between both parties. So those are essentially all the sort of other obligations. What we thought might be sort of important to sort of talk about, it's because we've received a whole lot of questions on this point, is what happens if you're actually paying employees in excess of the annualised wage under the award. So I'll run you through an example. So say, for example, the annualised wage arrangement under, say, the restaurant industry awards under clause 20.2 basically says that it must be at least 25% more than the minimum wage, which is under clause 18, then multiplied by 52 weeks. So taking an example of an award minimum annual salary of a level 4 classification, when you multiply the weekly wage by 52 weeks and you include the 25% uplift, that gives you an annualised wage of $58,467.50. So that's the minimum that can be payable under these provisions in order to satisfy those requirements that we talked about before. So what then happens if you wish to, or you currently pay an annual salary, which is in addition to that amount? Say, for example, you pay a salary to a level 4 employee, which is, say, for example, $70,000. What then happens to that, because it's more money on top of that annualised wage of $58,467.50. I've used a much more clear example, but there we go. Okay, so what then happens? So if you look at the award provisions, it says that if in a roster cycle, an employee works any hours in excess of the outer limits, so the 18 ordinary hours, which are track penalty, for 12 overtime. Those hours will not be covered by the annualised wage and must be separately paid for in accordance with the applicable provisions of the award. At face value, it says if you're paid an annual wage, regardless of what it is, if you work outside of the outer limits, you must be paid for that time during the applicable roster cycle or pay period. So essentially, the safest position is to pay these hours in excess of outer limits. That would be the most conservative and safest position. The thing, though, is that the provisions in the award, they're so new that they haven't been sort of subject to any sort of judicial interpretation by the Commission or the courts. So everyone's sort of testing out how to pay full-time employees' wage. And in considering sort of these provisions and the decision of the Fair Work Commission, we have thought about, well, what if our clients are paying well above? So using that example, $70,000. What we think is that it is likely, it's not guaranteed, but it is likely that in a situation such as this, where you pay, say, $70,000 instead of whatever that amount was, $58,467, you could reach an agreement where that additional amount counts towards any hours worked outside of the outer limit. But this would need to be drafted very carefully. Say, for example, again, I'm going to go through example, their annualized salary is $58,000, and therefore they're entitled to be paid anything if they work outside the outer limits. However, in addition to that, you basically stipulate that they're paid what's called an over award payment. You define that as an over award payment of $11,532, which is the difference between $70,000 and the other salary I mentioned. And you essentially say that that additional over award payment is spread evenly across each pay period, and that over award payment can be used to meet the employer's obligations to top up any sort of hours worked outside of the outer limits. And if there is a shortfall between the over award payment and the outer limits payable, that will be paid at the relevant time. But the intention is that the award over award payment will cover extend some hours worked outside the outer limits. Now, again, like I mentioned before, it's likely, it hasn't been tested by the courts. It is sort of, it can be risky. So normally we would only sort of recommend this where it's clearly drafted. So for example, the employment contract would have to say you're paid $58,467, which is the annualized wage. We're going to also pay you $11,000, whatever it is, as an award overpayment, and clearly outline what the agreement is. Any pay slip, for example, that is issued, the employee must also clearly identify the over award payment. So it's sort of clearly accounted for. Yeah, so basically we would only recommend this if where you've sought legal advice and it's been carefully drafted, because as mentioned, it has been tested. But you know, we have considered it, and I think you know, it can certainly be argued. Over to you again, Brooke.
Thanks, Aahana. We might just run through some FAQs. Like we said before, we've been working with clients for a fair few months now with the introductions of these provisions, and a lot of things, some main things that come up are in line with these three main questions. So can we offer time in lieu instead of paying the overtime payment in terms of the outer limits? And unfortunately, clause 23.5 of the restaurant award and clause 28.5 of the hospitality award still exists, and that time off instead of overtime doesn't apply to the outer limit provisions. So unfortunately, payment can only be provided and we cannot offset that through the use of time in lieu. Do we need to pay outer limits per week? And I think we may have received a question regarding this as well. The example that we used in the practical examples was based on a weekly roster cycle, but you can use up to 4 weeks to average the outer limit provision. So If you have a fortnightly pay cycle or a fortnightly roster, you could average the overtime over 24 hours over the fortnight and average the penalty hours over 36 hours over the fortnight. So it's not week to week. It should be in line with your roster cycle, which may be up to 4 weeks. Are there any other important upcoming changes? Yes, like we mentioned, the examples that we use today are pre-current pay rates, so pre-October 1st. So from the first full pay period within October, there will be new rates coming into play, and the pay guide should be published quite soon from the Fair Work Ombudsman. Practical next steps. So we wanted to wrap up with some things for your business to consider and take away from the webinar today. And these are the steps that we've kind of guided clients and through the last couple of months on what we needed to do come by 1st of September. We're obviously conscious that we're past that date as of now, but there will be, we still believe these are the steps that you should take if you haven't already had considered these provisions and put certain things into place. So first step is to notify staff of the changes regarding what the outer limits mean and the need to record meal breaks. So sending a communication piece, you may want to also send a policy or introduce a policy regarding the need to clock in and out for their breaks. Step 2 is to run an assessment of what are the current technology platforms and infrastructure that your business has in place, and how will your time and attendance and payroll system work to support and manage these changes. So for instance, KeyPay, Employment Hero Payroll, has things like rostering warnings that you can preset and ensure that your managers are working in line with these outer limit provisions and they're being flagged in the system. So prior to actually needing to pay and work in line with the obligations, you're forecasting and managing the hours up front. And the rostering platform is really great for that. The payroll system also has award interpretation. So when those outer limits are payable, then the system essentially calculates what would be payable within that pay cycle. Okay. So it's really important to consider how you're going to manage these changes in a practical sense, because manual intervention will be a bit of a struggle in making sure you're meeting these obligations. Step 3, we recommend undertaking a sample wage reconciliation and rostering and looking at your rostering arrangements. So this will help identify who may be working on a current roster cycle that is going to be largely impacted by these provisions, and what the business would be obligated to pay from September onwards if we keep the current rostering arrangements. If you identify that these rostering arrangements should be changed and the business has the ability to change it, then we would recommend upskilling your line managers to consult with staff requiring the rostering change and chatting with them about the need to change the roster and also what that would look like in line with whatever, commitments they may have outside of work. Following from that, within your assessment of looking at the wage reconciliation sample and rostering arrangements, you may be able to identify some staff who may be applicable for a full-time hourly arrangement. If you think there is too much of an administrative burden, then we highly recommend considering what a full-time hourly arrangement looks like with your staff. Obviously, some key considerations of that is looking at your attraction strategy and your retention strategy. If you think that hours of work fluctuate too great, if the employee will be impacted by those, lull periods where their take-home pay would drop, whereas obviously a salary is fixed throughout the year and quite consistent with what they're going to take home each week. So definitely a consideration that we recommend looking at. Moving on to the next part is upskilling managers to consult with those who you have identified who maybe want to go on a full-time hourly arrangement. You would need to, this is a significant change in terms, so you would need to go into a new written agreement for something like this. So you would need to consult the staff on this change and issue new employment contracts if they were agreeable to the change. If the employees are not moving to a full-time hourly arrangement, we still need to issue documentation, as Aahana mentioned, as we need to go into a new written agreement for these new provisions. And unless you've are a bit of a psychic and envisage these changes coming into play and have existing employment contracts with these provisions, you would need to introduce new documentation, which we'll be sharing after this webinar in relation to what you need to have them read, acknowledge, and agree to. Then from September 1st, which we're past that date, we recommend that you have all your new full-time salary employee contracts up to date with the new annualized wage provisions within those contracts. So if you've got an existing, you may think, you know, this is the time that we need to revamp our employment contracts anyway. Employment Hero obviously has a plethora of templates within the system. You may want to use this as the opportunity to recontract staff into full-time salary employment contracts that are up to date and in line with legislative frameworks at the moment. If not, if you have an up-to-date full-time contract, you just need to send that additional annualized wage arrangement document. But with all new hires from now onwards, we recommend making sure all your contracts are up to date so you don't have to do this again. Okay. Resources. So at Employment Innovations, we do quite a lot of work. As I mentioned before, we work with all different industries of all different sizes. We are quite predominant within the restaurant and hospitality spaces, but we have a large range of industries that we work with. We wanted to make available our industry award summaries. So you will be shared this presentation following this webinar, which will have those links to download those award summaries, which includes a bit of a summary of what we discussed today. You'll also get a copy of this presentation so you can run through the content for some light reading if you wish to do so, but this webinar is also recorded. And like I said before, we will also be emailing the annualized wage document that needs to be put in place if employees remain on a full-time salary arrangement, and that will be emailed over to you in this follow-up and will likely be made available on the Employment Hero templates quite soon. So look out for that. Aahana, did we get any questions in the Q&A box that we can answer?
Yes, we did. I think these are, a lot of them are suited to you, so I'm going to read them out to you, Brooke. Okay. Do these changes affect other awards or just the RIA or HIGA?
Good question. There are different provisions depending on what award applies to your business. There are quite a few provisions that came into play. Was it 2019, Aahana, or 2020? Started 2020?
Started 2020, yep.
Started 2020, that have very similar provisions to what we spoke about today. RIA and HIGA are different where they are preset. I guess the industry bodies wanted to preset those to make sure businesses didn't need to do that themselves, but there are similar in other awards, but also some awards are silent on those provisions. So it's dependent on what award applies to your business.
Yeah.
But yes, these are just in relation to the Restaurant Industry Award, what we discussed today, and the Hospitality Industry Award.
Yeah, great. Thanks, Brooke. Another one, I mean, you may have sort of answered one about, you said the examples we're using are week to week, but if we talk about a fortnight, then can you sort of use one to offset the other? I think you've already answered that, but yes, correct. It can be averaged over a 4-week roster cycle, but that's the maximum. It's a 4
correct.
weeks.
Yeah.
There was another question which said, is it roster cycle or pay cycle? For example, it's a 4-week roster, but I pay weekly.
Yeah, that can differ, definitely, and that's quite common. It should be based on your roster cycle. So you still might have a weekly pay cycle, but you can roster up to 4 weeks. So 4 weeks is the maximum, but you can still pay employees weekly. I'm not sure how that interacts with your kind of payroll infrastructure, if you have rules that you can build around that. But yes, it can be based on a 4-week maximum roster cycle, and pay cycle can differ to that.
Thanks, Brooke. There's another one which says, what if an overpayment is identified? I mean, if an overpayment is identified, I guess you're doing the right thing. You're paying your employees well above the award. If your question is, can you sort of take that back? I don't think you can. That's just sort of, you can't then sort of recoup that from the employee. So yeah, look, I think if the overpayment is identified, then you should give yourself a bit of a pat on the back because you've done well. There's a couple of, I might just mindful of time. Are junior sous chefs included in the managerial level of the HIGA?
Tricky one. It really is dependent on your hierarchy. So there are a specific description of duties and responsibilities, as well as experience and qualifications that align with the managerial classification under the Hospitality Award, which you would need to meet. So it is dependent on the role and the hierarchy. That role of the managerial classification needs to report to senior management. So they need to report to someone who is essentially award-free, who is in charge of operational budgets, forecasting, hiring and firing, creating and developing procedures and policies. They need to report to someone like that. So a junior sous chef, unfortunately, dependent on the size of the restaurant or venue, it really depends on your hierarchy and who they report to and what level of experience and what they're responsible for as that junior sous chef. Sorry, in a roundabout way to answer that.
Thanks, Brooke. And maybe we just have time for one more, and I can take this one, but it says, if the award is silent, what is the best step forward? Now, yes, you need to look at the applicable award. A lot of them do have provisions around annualized wage arrangements. If they don't, you don't have to pay an annual salary just in reliance of the award. You can pay an annual salary in reliance of under a contract of employment, but there needs to be very sort of specifically drafted provisions in there about setting off any award payments. So we would recommend that if the award is silent and you want to pay an annual salary, get your contract checked, get some HR or legal advice. And unfortunately, I think that's all we have time for now.
Yes, I think we're at time. So thank you everyone for joining us today. And thank you to Brooke and Aahana for taking us through all of that information. There was a lot of information in that. And I'm sure that if you do have any questions specific to your particular situation, or you need any additional HR or legal advice, their contact, EI Legal and Employment Innovations contact details are currently on the screen. So please reach out if you have any specific questions to your situation. Also, a survey will be automatically launched after the webinar today. So it would be great if you could just take a moment of your time just to tell us how we did and fill it in. And we'll also be sending out some additional resources along with the webinar recording after today's session. But that's it. So thank you, Brooke and Aahana. Thank you everyone for joining us, and have a wonderful afternoon.
Thank you. Thank you, Lauren. Thank you, everyone. Bye.
Thanks, guys.